A follow-up to my previous video on the prospects of success on Lucy Letby's latest attempt to refer back to the Criminal Cases Review Commission, because I recorded the last one before they'd done the press conference. I've now had an opportunity to see that, also to read the very comprehensive report the panel of experts produced, and I'll put that, I'll link to that in the description so you can read it for yourselves. It does make very interesting reading. But the question is, will even this make a difference? And I said before, you've got this problem where the rules of the court are quite rigid, that you have to pass this three-part test. You know, the evidence wasn't available at the time, or you couldn't have got it with reasonable due diligence. The evidence has to be credible, and the evidence has to be more than just speculative. It's something that, had the jury seen this, then they may well have come to a different decision. And that's a very high hurdle, and in fairness, it seems to be one that Dr. Lee himself recognises. There's a very interesting comment where it was explained to him, and I'll try to remember to link it up there, that you know, we need to find something new here. So they definitely know the hurdle they're up against. But a lot of people in the comments have made the point and said, well, you know, it should all be about fairness, never mind the procedure and the rules. It seems a little bit harsh when fundamentally the question is she guilty or innocent? And I think a lot of people have a hard time grasping, I completely understand this, because it's something we do as well, is that innocence itself isn't necessarily a ground for appeal. There's a really good book, Alan Dershowitz book, Reversal of Fortune, about when he was doing a particular appeal. This is in the US, and they said the problem they had from the start was, effectively, they wanted to have a rehearing of the evidence, because it's like, look, you know, people drew all the wrong inferences from the evidence because of the, you know, possibly because of the way it was presented at trial. But they said, you know, it is right that we get a second go and somebody having a look at this. And it's a very interesting book, but that is the hurdle that they have to cope with, because theoretically, let's say I'm preparing a defence for a trial for my client, and somebody else comes and says, actually, I did it. Here's a video of me doing it, and here's my signed confession, but for whatever reason I decide not to call that witness, and my client is convicted. And I appeal, you know, somebody appeals then and says, well, actually, this is clearly somebody else did it. On a strict interpretation of the rules, that would be inadmissible. It's like when you didn't call the person at the time, and this is one of the issues we have in this. I mean, like I say, part of the problem is the defence, they knew that the prosecution were relying to some extent on Dr. Lee's paper. But you know, they didn't either call him or call anybody to rebut, or, you know, because they could have gone. We have this rule, there's no property in an expert. So the fact that one side has instructed an expert witness doesn't stop the other side approaching them and saying, we'd like to speak to you, we'd like to get a statement. I mean, that's a general rule. There is no property in a witness. Unless, you know, there's a condition there saying you must not approach prosecution witnesses, but usually, you know, your lawyers usually can. You can sort of say, well, these are the witnesses that the other side are relying on, and this is the same in criminal and civil. We'd like to speak to them, and they can't stop you doing that. I mean, the witness might not be very cooperative with you, but you are allowed to approach them. So that was an option open to them. So what will the Criminal Cases Review Commission do? Because they've put the application to them. Now, it's all meant to be about law and justice and procedure and things like that, but obviously the public interest element does come into this, and just public perception. And the previous head of the CCRC, she had to resign over that, you know, the poor guy who got banged up for 19 years for the R-word offence, and then, you know, the DNA evidence came out, and it was shown not just that there was sort of the conviction was unsafe, but it probably was a positive demonstration of innocence. And she came under a lot of flack for that, for, you know, dragging their feet, not referring it the first time. So will the CCRC just go, you know what, we just don't want the bad publicity here, we don't want this, boot it off to the Court of Appeal and let the Court of Appeal decide? Because, but like I said, they're supposed to, you know, anticipate what the Court of Appeal might do. And there is this, you know, this hurdle, but is it very inflexible? But let's say this gets referred back to the Court of Appeal, and they say, there's nothing we can do with it. You know, the test is very, very simple. You're not getting a second bite of the cherry. Is that the end of the route? You know, what about appeal to the Supreme Court, you know, the old House of Lords? Now, that is possible. That is possible. However, the House of Lords effectively selects its own docket, as the Americans would say. They pick and choose which cases. You don't get an automatic referral to the House of Lords. And what you've got to show to get to the House of Lords is, first of all the regular stuff, like there's an arguable appeal here, there's some good points to put forward. But it has to be a point of general public interest. It can't be something specific to your case. It has to be, well, actually the law in this area is unclear and it would affect a lot of people, so maybe we should visit it. If it's just a situation though where this is a trial and we think things went wrong in this one particular trial, that's something that the House of Lords, Supreme Court might say, well, it only affects this one person, so we're not going to take it. However, I think there could be an argument to say, we're not looking at, just a single thing about the law here. We're looking at how the law is interpreted and also whether that test is correct. So it could well be that you argue and say, this test is inflexible. So while you've got these three limbs you have to pass, maybe there should be a general limb for, or it seems otherwise in the interest of justice to allow this evidence to go in, or to allow a retrial or something like that. So I suppose they could argue and say, this is something that goes beyond this one case, because, this affects everybody, and it's not just these high profile, horrible cases like this. It's, lots of people sort of, have cases at, shall we say, low-level offending, where it's still just as important to them. It's like, I now have this evidence, I should be allowed to admit it. So that's, that's one possibility as to how it could end up at the House of Lords. But like I keep saying, it is going to be very much an uphill hurdle. Because one thing the Supreme Court have said is that they're not very keen on expert shopping. So where something turns on expert evidence, if it's a case of, well, we've gone around now and we've found an expert who actually supports our position, usually they're a bit sceptical about that. However, I think in this case, the defence have a nice argument and say, well, this is the expert that the prosecution relied on, and the expert is saying the prosecution misinterpreted their work. So, arguably, that gives them a much stronger footing. But let's talk about experts generally. How they work, because there is an interesting potential development there as well that some people are talking about. First of all, what is an expert witness? You can only call an expert witness to give evidence on something that is outside the cognizance of average everyday people. It has to be something where it's a specialist subject and it requires specialist knowledge. If it's something that normal people can have experience of, everyday life, you can't call an expert. Interestingly, experts, unlike all other witnesses, can give opinion evidence. They can say, in my opinion, I find this. In my opinion, I find that. Whereas, regular witnesses just have to say, these are facts that are within my own personal knowledge or purview. So that's why there is this sort of high threshold for getting experts in. But do you need any particular qualifications to be an expert? Not necessarily. And this is something that I will come on to momentarily, because this is what people are talking about changing. In this country, you can say, we need an expert. This is a subject that is, needs expert evidence, and you will propose experts. Now, in civil cases, we quite often use what we call single joint experts now. Okay, here's the deal. We'll just get one expert and they can opine and they act for both sides. Because that's the rule anyway. Even if you call an expert witness for one side and the other side put their own expert witnesses in, the duty on expert witnesses, and it's the same in civil procedure and criminal procedure, is they have to be independent. They are purely objective. They are there to assist the court. They're not to assist one party or another. And that's why I have rules about disclosing experts' reports and including disclosing draft reports. You can say, well, here's our final experts report. Great. Let's see the other three, and let's see the correspondence backwards and forwards. I mean, you get into issues about waiving legal privilege and things like that, but generally speaking, because the expert is independent, you can say, you've now come to this conclusion, but isn't it true that in an earlier report you came to a different conclusion? What made you change your mind? Was it all the emails from the solicitor? You can do that sort of thing. But generally speaking, if you identify the area that needs the witness, then you can call who you want. Now, judges might do little preliminary tests, especially if the other side objects, and say, well, how did you arrive at your expertise? And it has to be on that particular subject. So say, for instance, we've got somebody, it's a personal injury case, and somebody's banged their head really badly, so we need to discuss neurological evidence. And so we say, I've got this top consultant here. It's like, yeah, but he's an orthopaedic surgeon. It might be the court says, well, how is he in a better position to opine on this subject than anybody else? You know, it has to be an area that is within your particular field of course expertise. But you don't necessarily have to have professional qualifications. I mean, quite often you will have. But there have been cases where you've had people who are enthusiastic amateurs who've no professional qualifications whatsoever, but it's accepted they know a lot about a particular, especially some of the more niche subjects. I mean, to give one example from my own experience, I had a rather strange case involving a sheep, and there were allegations of basically gluing bits of wool to the sheep, painting it, designing it to make it look like it was the same species of sheep, or breed of sheep, sorry, but the argument was what grade sheep it was. And the judge actually said, well, isn't this a case that just cries out for a single joint expert? And we had to say, well, it clearly is, but there's a bit of a problem there in that there are two accredited, acknowledged experts on this sheep, but one's the claimant and the other one is the defendant. So, that's the sort of area you get into. But I say you don't necessarily have to have professional qualifications. Now, in the US, it's very interesting because in some jurisdictions they have these sort of Daubert tests, as they call it. Oh, that helicopter is clearly stalking me. Which one's that? Oh, is that another Kuldrose one? Yep, that's the Merlin. I mean, do I look like a Russian submarine? Oh, sorry, I was mistaken. It's the Coast Guard. I'll just wait till that passes overhead. Speaking of helicopters, the word helicopter, just to pad this out while he goes away, the word helicopter comes from the Greek helico, meaning spiral, and ter, meaning wing, as in pterodactyl. So my argument has always been that the P should be silent, there should be helicopters. But anyway, he's gone now, so I can get back to where I was. Have you seen the great film My Cousin Vinny, which a lot of lawyers like, both in America and here? Because, funny as it is, it's actually completely legally accurate. It's probably the most best portrayals of how cases act in practice. But apart from anything else, like the lawyers aren't particularly out to get each other. It's that sort of thing. The judges, being quite reasonable, calling out Vinny when he doesn't know the procedure. But in that, there's the famous scene where it's what's the timing on the engine? And the lass is in the witness box and says this is a BS question because it's a trick question because that engine wasn't in that car. But they test her knowledge of vehicles and they say, okay, she gives the snarky answer, proves she knows everything about cars, and say we accept her as a witness. And interestingly, that is now pretty much the test in a lot of jurisdictions where we don't look at your paper qualifications. We look at what do you actually know in practice, because for everything else, paper qualifications, you can still have them, but they might have expired. I mean, one problem with experts is, I'm not saying this is with all experts, but it'll be people who are effectively professional experts. They practiced in a field 20 years ago, but ever since then, they've just been a professional expert witness. And it's, have you been keeping up with the research? Have you been keeping up with the data? Is your knowledge 20 years out of date now? So that's the argument, that you might be better off with somebody who isn't as qualified as another person, but is more up to date and can, speak about sort of relevant topics. But the proposal that's come through is that experts should be registered. That actually, before you can become an expert witness, you have to have pass some exam or be accredited or, be otherwise verified in your field. I can see problems with that because it might be, that would sort of favour these professional experts because they'd probably be the people who'd go out and do whatever exam was needed. Whereas sometimes you might just need someone to go, this is a very niche, obscure subject. But we need to find some professor who delves in this, and they might never have occurred to them to be an expert witness or anything. You just hunt them down and say, you know a lot about this, would you mind being a witness for us? And so long as the guidance for witnesses as well is for expert witnesses, it's all set out about how their impartiality, and when they do their statement, they have to put in there and say, I understand my role as an expert, I understand that I am here just to assist the court, I'm not here to benefit one part or the other, I have to disclose everything even if it doesn't agree with the conclusions that the party wants. I have to disclose how I arrived at that. And also quite often, if you've got multiple experts, they'll do a thing now called hot tubbing, where instead of calling the experts, you give evidence as part of the claimant's case, the prosecution's case, and then the other expert gives evidence as part of the defence case, whether it's civil or criminal. What they'll do now is they'll quite often say, well, right, we'll get all the experts together and we'll effectively question them, collectively, and they can communicate with each other. So it's like, right, you say this, but what do you say about this? And now, having said that, if you want to discuss this, because the idea is that then it's the experts discussing amongst themselves, And that's just better than sort of trying to second guess what people are going to say and draft your questions accordingly. But at the end of the day, do people have to accept experts? No, they don't. Experts are just the same as any other witness, and the jury or the judge are perfectly entitled to ignore them and form their own views. Again, I'd be interested in your comments on that. Should people second guess experts? But people are allowed to say, well, in my experience, I don't agree with that person. I mean, there was a jury case once, the appeal hinged on, it was tyre evidence, and one of the guys on the jury worked for like QuickFit or something, and he sort of said to the jury, actually, no, these tyres, etc., etc. So the argument there was he giving evidence, in which case it was impermissible because he was giving evidence in the jury room, or was it just the whole point of having juries is they bring their collective experience? And in that case, the Court of Appeal said, well, no, I mean, the whole point of having a mixed bag of people is that they bring their collective experience. So the fact that somebody there was a tyre expert and he disagreed with the expert, he's perfectly entitled to disagree with the expert, and if he got the rest of the jury to go along with him, well, that's just how it is. I mean, and again, like I say, I'm interested in your comments here about should people second guess experts. But I think you can, yeah, because at the end of the day, people give evidence, people say things, and you can look at that and go, does that sound right? Is that interpretation correct? I might not be an expert myself, but I don't see how they draw this conclusion from that piece of evidence. Or it could even be, I just don't like the way they're giving evidence. They seem partisan. They seem to have come here with an agenda. They seem to be supporting one side or the other, even though they're meant to be neutral. I find that gives me a little bit of doubt as to exactly how objective they're being. But yeah, the whole role of expert witnesses is a complex and controversial one. So we'll just have to see what happens here. I mean, like I say, I don't want to sort of, I do not have a dog in this fight. I am, there was a 10-month trial. I didn't hear everything in it. I've seen some people have said, some of the stuff that's come out since about the notes and things. Like I say, I'm not sure how big a deal they actually are. But at the end of the day, I wasn't there. And I'm not going to second guess the CCRC or the Court of Appeal or potentially the Supreme Court. But I just thought if I explained some of the issues there, you might find those helpful. And like I say, I'll put a link in the description to the report. And if I remember, I'll also put a link back to the original judgment where the Court of Appeal dismissed leave to appeal on the back of Dr. Lee's evidence, and you can sort of go for yourselves and go, does that seem right? Does that seem fair? But anyway, as always, hope you found that vaguely interesting, vaguely informative, vaguely accurate. I am out and about, but I didn't venture very far today because my truck's got a flat battery. so I'm very much within walking distance. Although that helicopter is still clearly stalking me. I should ask them for a lift.